Hi, I'm Noah Weisberg.
And I'm Sayuri Kagami.
Welcome to Holland Estates. You're listening to episode number 543. So, how are you, Sayuri?
I'm good, Noah. You?
Good. We've got a very exciting podcast for today. Two of our favorite topics, and I'm told for the listeners and viewers as well, is taxes. How are taxes supposed to be paid, and RRSPs in the context of investments? So, two issues which we see time and time again. And the hope today is to bring some clarity on the tax side of RSPs and also discuss a really interesting case that deals with equity and how taxes should be paid.
Yeah.
So before we actually get into the main part of our podcast, I think what we'll do is just advise our listeners and viewers that we will be referring to a case out of Alberta. The decision is Morrison, and that can be found at 2015 ABQB 769, and it's Morrison and Morrison.
Yeah.
So, first and foremost, RRSPs. We see them in quite a few estate plans. They're quite a common investment tool. One reason being is that if you designate a beneficiary, the asset falls inside of the estate and it may avoid the payment of tax.
Yeah, so that's a great benefit of RRSP designations, avoidance of probate taxes. It also might allow you to creditor proof those proceeds in case there are any estate creditors. But of course, I think a lot of people fail to think about how RRSPs work and how that might affect you on your death. So as most people know, you put your pre-tax dollars into an RRSP, you invest those, you grow them, but once you actually take that money out of your RRSP, you have to pay the taxes. And so when you die, the Income Tax Act has a provision that says the proceeds are deemed to be your income immediately before your death. You've basically withdrawn all that money from your RRSP, which means you might have a big tax liability on death, because at some point those taxes do need to be paid. And a lot of people, I think, fail to consider this and fail to remember this when they're doing their estate planning, which can lead to some pretty big problems.
And that's in the context of both the drafting solicitor as well as the investment advisor, two people who you should be having these discussions with.
Yes, generally, because the Income Tax Act says that this is payable as the deceased's income, there's been accepted case law that when a person dies, if you have a designated beneficiary, that person will receive the proceeds of your RRSP or your RIF, and they actually receive that tax-free because ultimately it is the estate that is liable for the taxes.
So just to help me understand this, Sayuri, the idea is that the recipient receives the funds from the RSP, but the estate remains liable for the taxes only.
Yes, exactly. And the only exception there being if you have a spouse or financially dependent child or grandchild who receives it, and then they're the ones paying the taxes.
So I think this is a great leeway into the Morrison decision, which really addresses what happens when a recipient of an RSP receives a great big award, but the estate is basically left crippled as a result of the tax consequences owing in relation to the RRSP.
Exactly. Um,
So just a bit of context, perhaps. The estate left a residual amount to it was grandchildren equally, and there was an RSP payable to the deceased child, which fell outside of the estate.
yeah, and so the grandchildren would receive specifically $11,000. That was it. It was to be divided among all of them. It's a fairly modest amount. But when the deceased died, his funeral expenses and debts that didn't include taxes basically used up most of his estate. There was not enough. Once you added in taxes, which amounted to about $28,000 on the RIF, there was not enough to pay this $11,000 to the grandchildren.
Right.
And so without those taxes, the grandchildren would have received their gift from their grandfather.
Right. So an application is commenced, and the judge is tasked with the very difficult decision of should the estate remain liable for the taxes, notwithstanding the crippling result to the grandchildren and the benefit to the adult child.
Yeah. And so the court basically recognized that the estate is liable for these taxes, but relied in Alberta on Section 8 of the Third Judicature Act, which allows the court to make equitable remedies, and found that the court could fashion such a remedy in this situation. And so basically said the recipient of the RRSP holds those proceeds on a constructive trust up to the amount of the taxes owing. And basically the court found that the deceased intended to gift his child with the RRSP, but didn't intend for the estate to pay the taxes, intended for his son to pay the taxes.
Yeah, so the analysis is quite interesting. They do, of course, consider the Supreme Court of Canada decision in Pecor and whether a resulting trust applies, and didn't go so far down that road because the judge did acknowledge that. You're absolutely right. It appears that it was a gift, but that the deceased failed to appreciate the tax consequences that would result in the estate. The judge also interestingly considered rectification and decided not to rely on that due to the balance of probabilities, and ultimately led to the Judicature Act and using equity to remedy the situation.
Yeah. And the court sort of went into the ideas of constructive trust and said there was a benefit to this recipient of the RRSP. He received the benefit of the estate paying all these taxes, and that the estate really didn't owe any obligation to the recipient to pay those taxes. The estate owed a legal obligation to pay the taxes, but that wasn't an obligation to the recipient. And so the court found that it was manifestly unfair for the recipient to receive those benefits tax-free while the grandchildren received nothing.
Right, right. So it certainly is interesting that the judge relied on equity. What about in Ontario? So, of course, we have the Income Tax here, and the Income Tax Act, I believe it's section 160.2 sub 1, talks about there being jointly and several liability between the taxpayer and the recipient. Case law, of course, has suggested that the CRA will first seek repayment from the estate, although there are some cases which suggest that if there's a belief that the estate is insolvent, that the CRA will seek payment from the recipient of the RSP. But, as you rightly mentioned earlier on, this case does pave the way for application in Ontario.
Yep. We haven't seen any cases in Ontario, to the best of our knowledge, that have tried to apply this decision, but for those who come across this issue later on, that might be something that they want to do.
Yeah.
I think more importantly, this perhaps serves as a warning to those who are advising their clients before they die that you should really think of the tax consequences of RRSPs, because I'm sure a lot of us, we don't even consider the fact that yes, we can designate someone to receive these, but someone else needs to pay the taxes on them.
And certainly, I think that is one of the big takeaways from today's podcast is speak with your drafting solicitor, speak with your investment advisor. If you have an RRSP, if you have a RIF, how do you want to deal with the payment of the taxes?
Yes.
So really interesting case. Definitely encourage people to read it just from the application of the equity analysis alone. But I believe that does conclude our podcast for today. Until next time, we want to thank our listeners. I am Noah Weisberg.
And I'm Sayuri Kagami.
Should you have any questions, please email us at onemaster@hollandhall.com or leave a comment on our blog. Thank you, Sayuri.
Thanks, Noah.